Thank you, Mr. Chairman. There's no need for legislative reforms to the Voting Rights Act, which is one of the most successful laws ever passed by Congress. After the Supreme Court's correct decision in Shelby, the Voting Rights Act, including Section 2, remains a powerful statute that is more than sufficient to protect all Americans. With the latest guidance from the court on the proper application of Section 2 and the Brnovich decision, the Justice Department and private parties have the legal means to stop those increasingly rare instances of voting discrimination when they occur. The claim that there is a wave of voter suppression going on that requires expansion of the Voting Rights Act is simply false. Enhancing the integrity of the election process through reforms such as voter ID requirements and improvements in the accuracy of voter registration lists protects voters and is not voter suppression. A 2019 survey of 10 years of turnout data from all 50 states found that voter ID laws, quote, have no negative effect on registration or turnout overall or for any group defined by race, gender, age, or party affiliation. Voter ID laws are in place in numerous states like Indiana, Georgia, Alabama, Tennessee, South Carolina, Wisconsin, Kansas, Arkansas, Mississippi, and Texas because courts agree they are not discriminatory. There have been steady increases in registration and turnout in states that have implemented such reforms. The Justice Department has seen a steady decrease in enforcement actions due to a decreasing number of violations of federal law. During the entire 8 years of the Obama administration, DOJ filed only 4 cases to enforce Section 2. The Trump administration filed 2 Section 2 cases, so the frequency of the cases was exactly the same. Thus, there was no upsurge in Section 2 cases after the Shelby County decision. In fact, the Obama administration filed far fewer Section 2 enforcement actions than the Bush administration. That record does not support the claim that there are widespread, unlawful voter suppression actions being taken against minority voters. The Census Bureau's 2020 election survey also clearly demonstrates there's no wave of voter suppression keeping Americans from registering and voting that requires amending and expanding the VRA. Indeed, the Census Bureau reports that the turnout in last year's election was 66.8%, just short of the record turnout of 67.7% of voting-age citizens in the 1992 election. This was higher turnout than in President Barack Obama's first election. The Census survey shows that there was higher turnout among all races in 2020 when compared to the 2016 election. In fact, in an election year in which we were dealing with an unprecedented shutdown of the country due to a pandemic, we had, according to the Census Bureau, the highest voter turnout of the 21st century. The proposed amendments are almost certainly unconstitutional because they do not satisfy what is required by the Supreme Court's decision to justify continuing, much less expanding, the preclearance requirement. Any requirement that states obtain pre-approval of voting changes can only be imposed if Congress can show blatantly discriminatory evasions of federal court decrees, lack of minority office holding, voting tests and devices, voting discrimination on a pervasive scale, and flagrant or rampant voting discrimination. None of those conditions are anywhere to be found in any state in 2021. The new coverage formula is also unfair and violates basic due process principles and will not satisfy constitutional concerns since it will impose coverage even on jurisdictions that have never engaged in any discriminatory conduct because of problems caused by other jurisdictions within a state. The unprecedented practice-based preclearance provision also violates basic due process. It is so broad and covers such a wide spectrum of election procedures that virtually all changes made by state and local governments could be vetoed. The provisions also in the bill intended to overturn the Brnovich decision are ill-advised and interfere with the state's constitutional authority over the administration of election. They attempt to get rid of factors that are very relevant to determining whether a Section 2 violation has occurred. With the availability of Section 3 of the Voting Rights Act, which allows a court to impose pre-clearance requirements on a specific jurisdiction, that is much better than a broad-based coverage. It is not 1965, and there's no longer any justification for giving the federal government the ability to veto the election laws chosen by voters and their elected representatives. Thank you.
Thanks for watching the Heritage Foundation's YouTube channel. With more than 500,000 members, we are the nation's largest conservative research and education institution. We believe the principles and ideas of the American founding are worth conserving and renewing. Please help us further our mission by subscribing to this channel and sharing our videos with your family and friends.